court, counsel. Ladies and gentlemen of the jury, on May 1st, 2017, the defendant was given a blessing. He was given a baby boy, a happy, healthy, innocent, helpless baby boy. Mr. McAllister said at the beginning of this case that as with all blessings, there comes responsibility. Now that you have seen and heard all of the evidence in this case, you know that the defendant didn't want the responsibility of his blessing. You know that he didn't accept the responsibility of his blessing. And you know that he let his blessing die a long and painful death. As with Sterling's death, or with his life, the defendant refuses to take any responsibility for his death as well. That's why we're here. It wasn't my job. It wasn't my problem. I didn't know. He takes no responsibility. You as the jury get to decide. You make that decision. Is he responsible? Did he know? Should he have done something? This is the time that the state has to walk through the facts with you and to walk through the law with you and to put those two things together to help you as a jury decide what's the end result. How do all of these things fit, and has he committed a crime? Because you know in the beginning the defense told you this isn't a crime, it's just a tragedy. So that's another question you have to answer. Is it just a tragedy, or is it a crime that the defendant is responsible? The state has to prove to you this case beyond a reasonable doubt. We take that burden on in every case we do. We gladly take that on and prove that in every case that we have. Okay? But don't hold us to a standard that's higher than what it should be. Okay? You heard the instructions, and you now know that if after a full and fair consideration of all of the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. That's the standard. Firmly convinced. It doesn't mean beyond all doubt. It doesn't mean beyond any doubt. It doesn't mean beyond the shadow of a doubt. It's what's reasonable. Anything's possible, but that doesn't make it reasonable. We talked about that in jury selection. Anybody can throw out some alternative theory to explain why something happened or why they're not responsible, but is it reasonable? So just because it's possible doesn't make it reasonable. A reasonable doubt is based on common sense and reason. I mean, it's just that simple. It's the kind of doubt that would make a reasonable person hesitate to act. Now that's part of the definition of reasonable doubt. Keep in mind, though, that hesitation does not mean deliberation. You heard a jury instruction at the very end of those instructions talking about how it's your duty to talk to each other, to walk through all of this, to make decisions together in this case. That's called deliberation. Okay? Some people sometimes get the misunderstanding that, well, if I don't have the answer, I have to talk about it, and I have to think about it, and I have to maybe change my mind here and there, well, that means I'm hesitating. That's not what it means. That means that you are being reasonable, that you're listening to other people's opinions, that you're doing your job as a juror. So hesitation does not mean deliberation. It's when you get to that final end, when you're ready to say guilty or not guilty, that's when you start thinking about, am I not sure about this? Am I hesitating? A reasonable doubt is one that fairly and naturally arises from the evidence, or lack of evidence. It's based on reason and common sense and not the mere possibility of innocence. That's in the instructions. Okay? You're truth seekers. You are not doubt seekers. You see that in your instructions as well. It is your duty as jurors to seek the truth. So you don't walk into a case looking for the doubt, trying to find it in any corner that you can. You walk into it, you look at the evidence as a whole, you talk about it, and if nothing is fairly and naturally arising from that provides doubt to you, then there is no doubt. We have 2 counts in this case. Count 1, child endangerment causing death. Okay? Each of those are separate counts. Each of those have to be considered different from each other. Now, you're going to find out when we walk through these that most of the same facts supporting the murder first are a lot of the same facts that you're going to be using to support count 2, and that's fine. But you still have to look at each count separately. You also do not have to agree on the facts. The only thing that you have to agree on is the verdict. So, if you go back to the jury room and you need to decide whether a particular act occurred, and one of you says, well, I think it's this act that happened, and another of you says, well, I think it's this different act that happened, that's perfectly fine as long as the end result is the same. As long as, if you have different facts that you believe more than another, as long as the end result of guilty is the same, it doesn't matter that you're disagreeing. When you consider the evidence, you use your observations, your common sense, and your experience. Remember we talked in jury selection, you don't leave your common sense at the door when you come into a courtroom, when you sit on the jury. You get to use all of those things when you're deciding what evidence you believe, what evidence you find credible, who you find credible. Now, you have to try to reconcile any conflicts in the evidence, but if you can't reconcile those things, you accept what you find most believable. Okay? The defendant said he didn't know that Sterling was ill, that Sterling needed help. The evidence shows you that he did. You have to make a decision between those two conflicting things and decide which one of those you ought to find more reasonable. Lesser included offenses. Each count has a couple charges or so below it. Okay. The only way that you get to those lesser included offenses is if you find not guilty on the top. So you always start with your highest charge. Count 1, murder first degree. You go through those elements and you make a decision. Guilty, not guilty. If you find guilty, you're done. You don't go read through the next ones and say, well, what if it is this? Maybe this was wrong. Now, if you have some questions, if you're not sure, then obviously look at the lesser included. But if you get to count 1 and say, yep, guilty, don't go on to the next one. So here we have our elements for murder in the first degree. During the time frame, August 4, 2017, through and including the 30th of 2017, the defendant killed Sterling. That time frame is the same time frame you're going to have on count 2 as well. That time frame comes from the fact of when Sterling was last seen alive by someone other than the defendant, Cheyanne Harris, to the day that he was found by the EMT. And we know the last person that we know of to see Sterling alive and to be halfway healthy at the time was Brandy Harris. That Wopsy day she had on that whole Saturday. Said he looked a little thin, but he seemed okay. We know after that day, during that time frame, Sterling had a massive decline in his health. And something horribly wrong was going on at that house. You don't have to pick which day during that time frame. You don't have to decide if it was the entire time frame, if it was just the last few weeks, it doesn't matter. So that's where we have that particular time frame. So first element, he killed Sterling. Second element, Sterling was under the age of 14. Third, he acted with malice aforethought. Fourth, he was committing the offense of child endangerment. And fifth, his death occurred under circumstances showing an extreme indifference to human life. Now, I'm going to hop around a little bit on these elements because it's just easier to do it that way, and you'll see why in the end. But let's do the easiest one first. Okay? Sterling's birthday is May 1st, 2017. On August 30th, 2017, he was 3 months old. Almost 4. He almost made it to 4. Okay, so there's no question on element number 2. Nobody disputes it. That is proven to you beyond a reasonable doubt. Okay? And keep in mind when I say that, it's the elements of the case that have to be proven beyond a reasonable doubt. Okay? And that's it. So for each element, did we prove it to you beyond a reasonable doubt? No question on number 2. I'm now going to go to number 4. Element number 4. The defendant is committing the offense of child endangerment. What is child endangerment as defined in this particular case? We have to show that the defendant was a parent, that he intentionally committed a series of acts using torture or cruelty, and that the result to Sterling was bodily injury. Now, all of you know that the defendant is the parent. The parties stipulated to that. I don't know if you remember out of all of the evidence that you've heard, but at some point we stood up, said the parties stipulated, nobody questions. He is the biological father of Sterling. Right? That's proven. This is what's a little more interesting. Now, when we think of children being harmed and parents doing something that endangers them, a lot of times we're thinking some type of assault. They hit them, they shook the baby, they threw the baby up against the wall, whatever it may be. That's clearly an act. That's easy, right? Okay, but this case is different. This case is this long-term neglect, this long-term ignoring of Sterling. So what are the acts that we have in this case? Because we have to show a series of intentional acts. The state submits to you that during the month of August, every time the defendant entered that apartment and chose to do something else besides care for his child was an act. Every time. And pick whichever one you would like to fit into this. It was an act. Every time he walked in and sat down on his couch and turned on his TV and watched movies with Nala or played on his iPhone. Every time he did that, he chose not to walk in that room and take care of Sterling. It was an act. It was a choice. Every time he walked to his refrigerator and opened the door and got himself a pop or made himself a sandwich or got Nala some treats out of the cupboard, every time he put food in his mouth to satisfy himself but didn't walk in that room and feed his baby, that was an act. It was a choice. He had the supplies he needed. Every time he didn't walk to that cupboard and open it up and take out that formula and mix it with the water in the sink and go feed Sterling, it's a choice. It was an act. Instead, he chose to feed himself. Every time he went into his own bathroom, 2 steps, did that from Sterling's door with an adjoining wall to Sterling's room. Every time he walked into that bathroom and was able to use the toilet in fairly clean conditions and didn't go change the diaper of his son who had been sitting in it for at least 10 to 14 days in his own feces. Every time he did that, it was a choice. It was an act. Every time he got in that shower and he bathed himself while his own son was sitting in his filth in a room right beside there, that was an act. It It was a choice. Every time he went into his bedroom, because he was tired and he wanted to sleep or take his naps, every time he went in there and turned that fan on, while his son sat in that hot and sweltering room with a quilt over the window, with no air circulation whatsoever, with blankets layered over the top of him, every time the defendant did that to cool himself off, it was a choice. It was an act. He chose not to go in and help Sterling. The fan in the living room, every time he turned that on for his own comfort. Again, it's an act. That switching of the switch. That was an act that didn't involve going into his son's room and helping him. Every time he took a step in that tiny apartment where you could hear every cry that Sterling made, and he said that during his interview. Oh yeah, you could hear him anywhere in that apartment. And he was loud. How long do you think Sterling cried for during this campaign? You know, Dr. Koehn testified about the fact that over time, Sterling was going to become lethargic and not have the energy to move around much and to cry. But you know it was bad at the beginning. With no food, no water. Now the defendant wants you to believe that he wasn't home enough to know that this was going on. But he was home every day in that small apartment. And every time he took a step in that apartment and that didn't lead him to his child's room to care for his child, that was an act. It was a choice to do something else. How many times did he walk by that bedroom door? We also have to show that these acts were intentional. We know that they're intentional because he knew that Sterling wasn't being cared for. Right? He can say all he wants that he didn't know. But do you find that credible? Did you believe him when he told you that? That a day or two before Sterling was found on August 30th, that he was in that room and Sterling was holding his fingers and he was playing with him? That was not honest. He knew what was going on with Sterling, and he didn't care because he did nothing about it. He knew that Cheyanne was not doing her job. Now let's be clear about this. Define the roles in your household however you would like. That's perfectly fine. But keep in mind that your job, no problem. But if your spouse stops and your child becomes ill, becomes hungry, needs change, and there's no one else to do that, then it's still your job as the parent to step up and to keep your child safe and to keep your child healthy. So this excuse of, it wasn't my job, doesn't fly in this situation. It was his job to be a parent and to care for his child, no matter what. What you know is that within a 26-day period, Sterling went from thin, what we know is probably being underfed from Dr. Klein's testimony. That malnourishment had been going on for longer than just the last few weeks of August, but it wasn't to the extreme until the end of August. So maybe he wasn't getting enough up until that time, which is why he was so thin, but we know in August he was getting nothing from where he. So within that 26 to August 30th, he went from thin to starving. You take one look at that last photo of Sterling taken on July 15th, 2017, and you compare that picture to the photo from the autopsy of Sterling's face. And you ask yourself, how could anybody believe that he didn't know that something was wrong with Sterling? Any person looking at Sterling would have known that something was wrong with him. Now, we also have to show that these intentional acts, and keep in mind that the intentional goes towards the act. It goes towards the step that he took in his apartment that didn't lead to his baby's room. It goes towards the feeding himself instead of feeding Sterling. That's the intentional. It's not that he intended to kill Sterling. That's not part of the elements of this crime. So don't confuse those two. The intentional was he intended to do the act. And again, pick whichever act you'd like. We also have to show that those intentional acts were using torture and cruelty. Now, there's no legal definition for these. You just use your common sense. Okay, we all have heard the word torture and cruelty, and we have all have our understandings of what they mean. But here's a few suggestions. Torture. Maltreatment. Cruelty. I think this one fits very well for this particular case. The callous indifference to pain and suffering. Did you see that going on here? So what evidence supports the torture and cruelty? The photos, the testimony of the first responders, Dr. Klein and Dr. Huntington's testimony. All of those things tell you that the last weeks of Sterling's life were torturous and they were cruel. That room he was in was oppressively hot. You know that from every person that walked in there. It felt like it was 10 to 15 degrees hot in there. There was no air circulation. They put a quilt over the window. Tony Friedrich called the sheriff because she could tell. She knew the minute she looked at Sterling, something's not right. The smell was so bad, Jason Russell had to hold his breath. He had to hold his breath to crouch down by Sterling to look at the evidence because it was so bad in there. Yet the defendant wants you to believe that, well, he was in that room just a day or two before, and, you know, smelled like dirty diapers, but no big deal. He had layers of soap, blankets, and clothing on top of him. Now you think about that. Did you think, when you saw that, how all that clothing was stuffed in with Sterling? Did you wonder what that was all about? Is it reasonable to infer that they kept stuffing things in there just to continue soaking up the urine? Why else would he have all those things stuffed in there with the layers of the blankets on top of him? Everything around him was soaked. Even the things on the floor underneath the swing was soaked because it was dripping down. He had a diaper full of sewage. And that child had not been changed for at least 10 to 14 days. You know that from Dr. Huntington's testimony. He had exposed raw skin, never been treated, still rubbing up against that one diaper that he had on, having the feces and the urine on top of it, soaking into it, with the E. coli getting into his blood, into his system, making his bodily organs shut down. He was hungry and he was dehydrated. And think about this one. During that time frame, he was never felt. He is a 3-month-old baby. And you know from Dr. Huntington's testimony that he was never touched. The maggots and the bugs, the flies, wouldn't have been in the places that they were had he been touched or picked up or moved in any way. Babies do need food, they do need water, but they also need touch. They need care. and he sat in that swing by himself, all alone, in a dark, hot room with no one to help him. Is that cruel? Is that torturous? It is almost beyond imagination what Sterling had to go through the last several weeks of his life, completely alone in that room. That, ladies and gentlemen, is cruelty and torture, and that occurred because the defendant chose to do nothing. We also have to show that the intentional acts of torture and cruelty resulted in bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. We don't need to discuss this any further. Sterling's dead. Element 4 is proven beyond a reasonable doubt. That's the child endangerment. Element 1, we have to show that the defendant killed Sterling. If the defendant's actions caused or directly contributed to Sterling's death, then the defendant killed Sterling. That's the definition you're given for that. Every time he entered that apartment and he chose to do something else besides care for Sterling is an act that caused or directly contributed to Sterling's death. There were 2 adults in that apartment. Both of those adults had the moral and legal responsibility to care for Sterling. The defendant is not excused from this responsibility because he was too tired, or because diapers made him sick, or because it just wasn't his job. The defendant killed Sterling. Element 1 is proven to be beyond a reasonable doubt. Malice aforethought. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of hatred, or with an evil purpose, or with an unlawful purpose. Further on in the definition of malice, you'll see that it may be found from actual hatred or by a fixed and deliberate intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious acts. And it doesn't have to exist for any particular length of time. Now, that right there is not a problem in this case. Usually that's something that we have to argue a lot about. Because when we argue when someone pulls the trigger on a gun, did they have the malice aforethought right before the form? It happens so fast because they have formed the malice aforethought. We know that for the month of August, this malice aforethought was ongoing. At the minimum, we know it was there at the very end of Sterling's life. So did he intentionally do a wrongful act to the injury of Sterling out of actual hatred? This is one of the options. And again, these are the ors and the mays. So you don't have to agree to what option of malice you're picking. You just have to agree that malice exists. Did he do it out of actual hatred? Well, you can infer that from the evidence. He questioned whether Sterling was his. And we know that from his own family members, that he questioned whether Sterling was his. Go back to the 911 call. When he called, one of the things he said was, "My girlfriend went to see the son." This was in the first part of that 911 call, where he supposedly just found his son dead. And in that call, he calls Sterling the son. Now, what does that tell you? That shows detachment. That shows you the lack of connection that he has to Sterling. I was getting ready for this case, and my husband tries to avoid hearing much of anything about what I do because he doesn't want to hear it, but I needed to run some things by him. And as I went through and explained some certain things and thinking about how I wanted to present it, I got done and I said, what do you think? He goes, well, the first thing that I think is you need to stop calling him the baby. And he says the second thing is you actually called the baby it one time during that conversation. And I stood back and I thought, wow, I guess I did. Because to deal with this case, sometimes you have to stand back and distance yourself. I knew that to come in here and argue this, I could not get emotionally attached. So I always called Sterling the baby. And that's what he called him when he called 911. My girlfriend went in to check on the son. He never once told his good friend Jordan that he had a son, but talked about Nala all the time. He saw Jordan almost every day. Jordan was in that apartment, supposedly a good friend of his, and he never once told him about Sterling. Jordan didn't even know they had a baby. But he talked about Nala all the time. Sterling was interfering with his relationship with Cheyanne. He was interfering with his finances. He was interfering with his life. So infer what you want when it comes to that section where they had actual hatred for Sterling. Did he intentionally do a wrongful act to the injury of Sterling with an evil or unlawful purpose? Well, what else do you call what happened to Sterling? Anything but evil. How can his allowing Sterling to die an extended painful death in his own home merely because he couldn't be bothered with taking care of his own child, how can that be anything but unlawful? You can also find malice from the acts that occurred, from the conduct, from the means used in doing the wrongful and injurious acts. Okay, ladies and gentlemen, this is why we showed you the pictures. I'm sure when those came up, you may have been angry at us for doing that, because who wants to look at that? But those photographs show the malice in this case. The nature of the injuries that he had shows the malice, the malnutrition, the dehydration, the infection from diaper rash. The mechanism of injury, the acts, the denial of critical care. And keep in mind that the victim in this case is a child. It's a 3-month-old child. He couldn't care for himself. Sterling couldn't protect himself. And that's the person that he chose to commit these acts upon, a defenseless state. Here's the easiest thing that you can do with malice. You are allowed, you're not required to, but you're allowed to infer that malice exists if you believe the state shows that the defendant committed count 2, child endangerment resulting in death. Okay. The reason that you get to infer that, because if you commit that type of crime, then it's just a given that malice is there. That's what the law says. Just infer it. You commit that type of crime, malice existed. All right, so if you find that he committed count 2, child endangerment, causing death, then you can just say, well, malice existed, and it's just that simple. Element 3, malice is proven beyond a reasonable doubt. Extreme indifference. Sterling's death occurred under circumstances showing an extreme indifference to human life. There should be no question about this. And again, this is a common sense definition. You know what Sterling looked like when he was found that day, and how he was left like that for how many days and weeks. You know that there was food in the cupboards that he could have been fed. You know there's a bottle in the cupboard that could have been used to feed him. There was water in the sink. There was a onesie, clean onesie, in the bedroom he could have been put him. There is a bouncy seat that looks like it's never been used, sitting right beside Sterling in that bedroom. with a clean, folded up blanket that could have been given to him. And instead, what actions are taken? They put air fresheners under Sterling's skin because it smelled to death. That is extreme indifference to human life. These were not acts of careless neglect. These were acts that no child should ever have to endure. What was Sterling experiencing the last weeks of his conscious life? These circumstances were extreme, they were indifferent, they were in complete disregard of human life. And that's murder in the first degree. That was your first count. Count 2, child endangerment resulting in death. A little bit different, but it's going to go a little quicker because a lot of it's the same facts. We have to show, element 1, the defendant was the parent of Sterling. 2, Sterling was under the age of 14. 3, the defendant willfully deprived Sterling of the necessary food, water, health care, or supervision appropriate for a child of Sterling's age. 4, the defendant was reasonably able to provide. And last, as a result, Sterling suffered substantial physical harm. I should have said second to last, because also Sterling died as a result of the substantial physical harm. Those are the elements that we have to prove beyond a reasonable doubt in count 2. So willful deprivation. We don't need to deal with elements 1 and 2, because we know he's a parent and we know Sterling's under the age of 14. So those are proven beyond a reasonable doubt. Willful deprivation. Go back to the previous arguments we talked about. What did Wayne Feaster say when he talked about the defendant leaving the community, being excommunicated from the faith? He said that in his faith they call that living for self. And that's exactly what the defendant was doing. Any person looking at Sterling would know that he needed help. His claim that Sterling looked fine the last few days of his life is not credible. He testified that he didn't trust Cheyanne to feed his dog. Yet then he tells you that the only thing he did wrong in this case is trusted the wrong person to care for Sterling, for his child. Did he willfully deprive? Did he know what was going on? Absolutely. He took better care of his dog than he took care of his baby. Was he reasonably able to provide? He had plenty of food in his refrigerator. He had plenty of water in his sink. He had formula, bottles, diapers, wipes, ointment in the house. Most of that was sitting in Sterling's room. He had $140 to $280 meth habit a week. Didn't you find that interesting when he testified? And he was questioned by Mr. McAllister about how he supposedly, the last couple of weeks before Sterling's death, he went to his third cousin at work and asked for $20, but that was for formula. And Mr. McAllister asked him, that was actually for drugs, wasn't it? And his response was, well, I use my own money for drugs. Does that make any sense to you? So he has no problem begging, borrowing, stealing, supposedly to provide for his family, but when it comes to his drugs, that will just come out of his paycheck. He was able to get health care at work. He chose not to. He could afford the dog, but he couldn't afford his own child. He had a good job. He was making money that could have gotten by. And he chose to spend that money on drugs. He chose to spend that money on himself. He chose to spend that money on knowledge before he could spend it on Sterling. Okay, so he could reasonably provide what Sterling needed. Element 4 is proven beyond a reasonable doubt. 5 and 6, where we're talking about substantial physical harm, these are the same discussion that we had for causing death in count 1. We know that this is a homicide. means it's the death at the hands of another, and it's from the denial of critical care. What this is the death at the hands of his own father. Right? He didn't place his hands around Sterling's neck and strangle him. He didn't take Sterling and shake him so hard that it tore up all the blood vessels in his brain and he couldn't survive. But what he did was let him sit in that room with no food, no water, no light, no nothing, and just kept walking by the door. The defendant's actions caused substantial physical harm to Sterling. Sterling died as a result of that harm. And that's all that's count number 2. So, did the defendant commit murder in the first degree? The defendant killed Sterling. Sterling was 3 months old. The defendant had malice aforethought. He was committing the offense of child endangerment. Sterling's death occurred under circumstances showing an extreme indifference to human life. Therefore, he is guilty of murder in the first degree. Did he commit child endangerment causing death? The defendant was the parent of Sterling. Sterling was 3 months old. The defendant willfully deprived Sterling of necessary food, water, health care, or supervision. He was reasonably able to provide those things. As a result, Sterling suffered substantial physical harm, and as a result, Sterling died. Therefore, the defendant is guilty of child endangerment causing death. Ladies and gentlemen, it's that straightforward. Okay, there's really not much dispute to these facts. Really, the only dispute is whether or not you're going to hold the defendant responsible for what he did. And the state is asking that you hold him responsible for what he did and that you find him guilty on both counts.
May it please the court, counsel. Ladies and gentlemen of the jury, at the outset of this case, Mr. Blair stood in front of you and told you this is a tragedy, not a crime. And that's exactly what the evidence shows. When we talk about a tragedy and not a crime, it's important to know the difference. As Ms. Timmons pointed out, the evidence shows this is an emotional situation. This trial has not been easy for any one of us. When something happens like this, when a child dies, it is normal for us to react emotionally. I suggest to you that to react any way other than emotionally makes us something less than human. But that emotional reaction that we have to a situation like this is not justice. It's vengeance. It's our desire to explain to ourselves how something this terrible can happen, and the natural human desire to hold someone accountable for that. And that's the difference between a tragedy and a crime. Your duty here is not to seek vengeance. Unfortunately, it's not to have an emotional reaction. Your only duty is to do justice. We'll talk with you about justice. Briefly, though, I want to let you know that I think this is a beautiful courtroom, and I bring that up not to flatter you, but there's a reason. Because as I mentioned to you, I normally practice in Dubuque. And one of the things that I love about practicing law in Dubuque is that over the judge's desk, we have a wooden carving. It's in Latin. And that carving says fiat justitia. I don't know if you're familiar with Latin. I'm not terribly familiar with it. But what that means is let justice rule. And that's half of a very important saying. The full saying is actually fiat justitia ruat caelum, which means let justice rule even if the heavens fall. That's how important is to do justice. Your job here is to look at the facts, look at all the facts in this case, and then to apply the law to those facts. And when you do that, it becomes clear Mr. Koehn is not guilty. Let's start with one of the most important facts. A fact that has never, ever been disputed in this case. Cheyanne Harris is the primary caretaker for Sterling. That is absolutely undisputed. This is important because she was at home with Sterling. She knew when Sterling was fed or not fed. She knew when Sterling was changed or not changed. I want to be 100% clear about this when I talk about Ms. Harris. I am not up here to villainize her. Villainize her, I believe, would be to villainize depression. Far too much of that in our society. This her depression makes this a tragedy. When we talk about blaming people, I think that comes from the natural desire to seek vengeance and not justice. The evidence in this case is absolutely undisputed that she stayed at home with Nala and with Sterling. Her testimony, the way that Mr. Koehn was raised, is that a woman took the child-rearing role and a man took the breadwinner role. That may not be the role in your household. It's not necessarily the role in my household. Even without that evidence, it is still clear that Ms. Harris did not work outside of the home. Mr. Koehn did work outside of the home. She stayed home. She took care of the children. Now, the state has talked a lot about the fact that Mr. Koehn did not change diapers. And I think that it's important to talk about that. This had been their relationship from the beginning, from now. This was not a conscious act or a conscious decision, where when Sterling was born, Mr. Koehn said, I don't do diapers. As Nala was an infant, he relied upon Ms. Harris to change diapers. This is something that you were both aware of. This was not a situation that is unique to Sterling. Even without that, it would make sense for him to trust her to do this. Why would you not trust the person who is at home and is taking care of your daughter to also take care of your son? Now, the state has talked with you about the smell. Mr. Koehn sat in front of you under oath, explained to you that he smelled, that the room smelled, and that he talked with Ms. Harris, and that he took a bag full of dirty diapers out there and thought that that was a lingering smell. As has been pointed out, you do not leave your common sense at the courtroom door. Those of us who have raised children know about the smell of diapers, know that the smell can linger. These facts show Mr. Koehn is not guilty. Another very important fact comes to us from Mr. Koehn's interview with Agent Turbot. I'm going to bring this up. That interview happened hours after he called 911. His interview with Agent Turbot was not a situation where he had heard all of the state's evidence, heard from their experts, and was able to tailor what he told Agent Turbot. This happened hours after he called 911. He told Agent Turbot he trusted her to feed Sterling because that was her thing. He said that he worked nights, but it is very important to remember that Mr. Koehn did in fact feed Sterling while working 70 to 80 hours a week, longer hours than he was actually getting paid for, with double loads, staying in his truck and paperwork. He was feeding Sterling. While he was on the road, I want to point out as well that we know, not just from Mr. Koehn's testimony, from the testimony of Jordan Clark and the testimony of David Nugent, Mr. Koehn was far from exhibiting an extreme indifference for the life of his son, far from acting with malice and forethought, far from doing acts of cruelty as the state alleges, was on the road trying to get things for Sterling. Contrary to the state's assertion that he took better care of his dog than he took of his family, we know that to not be true. No one was telling Mr. Koehn, hey, I'm feeding the dog, I'm taking care of the dog, as was going on with regard to Sterling. If you look at State's Exhibit 29, which the state has shown you, you know there was formula in the house. You'll recall Deputy Russell's testimony. I believe he said, but you'll recall for yourselves when he said that the blue can was about 3/4 of the way full, the other can behind it, which said sensitive on it, was about 1/4 of the way full. Mr. Koehn was providing for his family. He was not willfully neglecting the needs of Sterling. He did, as he testified, and as we've heard about, observed that Sterling was underweight. He told that to Sheriff Heumann. You saw him say that on the body camera video. You heard him tell that to Agent Turbot. Sterling was growing, but not growing around. And Brandy Harris told us that she had observed that he was stretching out. That's what she told Agent Turbot when she talked to as well. Not to the extent, however, that Brandy Harris, a grandmother who cares for Sterling, was concerned enough about it to do anything about it. I want to be clear, I'm not saying that was a failing on her part. I'm simply saying, noticing that Sterling was underweight did not give concern when she observed that. The state wants you to hold Mr. Koehn accountable for noticing the same thing. As I said, Mr. Koehn fed Sterling. And the timing here is crucial. When Agent Turbot said, when did you last do it? He said, about 2 weeks ago. If Mr. Koehn thought or knew or had any inclination that Sterling was dying from malnutrition and dehydration, why would you tell a law enforcement officer it's been about 2 weeks since I fed him? That indicates to you that Mr. Koehn did not know what was happening with Sterling. Why not say, a couple of days, we take turns, I can't remember. Instead he says it was about 2 weeks ago. That timing is exceptionally important because we know through the testimony of Dr. Huntington that the insects form over a period of, it was estimated, about 10 to 14 days. Recall Dr. Huntington's testimony about the 4-month-old child whose stool he tested. That child did not have sepsis. The temperature may have been off. He talked about an 85-degree room. I believe the testimony from Agent Teal was 81 degrees. The timing may have been off, but I'm not here to nitpick about that. Even if you accept the state's time frame, it had been about how long since Sterling had been changed? About 2 weeks. This is very important. If, as the state suggests to you, Mr. Koehn was aware of what was going on for as long as it was going on, why would he tell a law enforcement officer that it's been about 2 weeks since I fed the child? In fact, I'm going to suggest to you that this shows not that Mr. Koehn committed a crime, but that prior to that 2-week period, when he was assisting with the feeding, that his feeding is very likely one of the things, his attention to Sterling was very likely one of the things that actually kept Sterling alive. This is not the acts of someone who is acting with an extreme indifference to human life. These are the acts of someone who relied upon a child and infant's primary caregivers to provide these things. Now contrast what Mr. Koehn told Agent Turbot with what Cheyanne Harris said when she was interviewed by the DCI. She said that she had fed and diapered Sterling the day before. We know that is not true. We know that from the testimony of Dr. Klein. We know that from the testimony of Dr. Huntington. She was going to hide when she last fed and diapered their infant son in the Department of Criminal Investigation. It's likely she would hide that from Mr. Koehn as well. We do know there were some attempts, at least, to feed Sterling in the last hours of his life, because Deputy Russell testified about the bottle that he found in that room. The bottle that was not empty. The bottle that had not yet turned. What this evidence shows is that when Ms. Harris went in there to feed Sterling, she didn't follow through, that she lost interest. Consistent with the depression that we've heard Dr. O'Hara testify about. And again, this shows Mr. Koehn is not guilty. The evidence that we have seen throughout this case backs up what he told you under oath. Recall that he talked quite a bit within hours of calling 911. At that time, he did not know that the entomological evidence was going to show an estimated time period of 10 to 14 days. It would be a couple of weeks back. He did not know what the complete investigation was going to show. At no time was Mr. Koehn able to tailor the statements that he made to Sheriff Heeman, to Deputy Palo, or to Investigator Turbot based on the evidence. These are statements that he's making within hours of calling 911. Let's talk about the 911 call. Ms. Timmons talked with you about the fact that Mr. Koehn said the son. Use your common sense. We've all heard people refer to family members as the wife, the son, the daughter, the husband, using what's called a definite article instead of the possessive mind. It does not necessarily indicate detachment. It is a normal pattern of speech for people to use. The state is trying to stretch so far to try and show this, get a conviction that they're reaching even to that pattern of speech. On the 911 call, he says she fed him at 9. Now, he wasn't present for the feeding time. Where did he get this information from? Must have gotten that from Ms. Harrison, that Sterling had supposedly been fed at 9. How do we know that Mr. Koehn was not present at this supposed feeding? Because on the 911 call, he says, quote, "She just woke me up." The mail carrier arrived, Tina Shattuck, quote, "She woke me. I was sleeping. I truck at night." When he talked with Sheriff Heeman in the bedroom, see this on the body cam video, "I got the phone and called y'all right away." Now, in his interview, he talked about 11:30 or 11:40, but you heard him testify about the fact that his phone was on Mountain Time, an hour behind Central Time in Iowa, which means that it was about 12:30 or 12:40 p.m., approximately, when he was awakened by a crying Cheyanne Harris saying he's gone. Goes outside with her cell phone, tries to call 911. Yes, he smokes a cigarette. He's out there trying to find a signal. At this point, he is aware Sterling has passed away. Cross-examination, he was asked about, why didn't you grab your son to your chest? Why didn't you run from door to door screaming for help? I have no idea how I would cope with the death of one of my children. And I hope that none of us ever have to find out how we react to that situation. But I also hope that based on our reaction and our coping mechanisms, that no one tries to argue that I am guilty of a crime. There's no prescribed way to react to finding out that your infant is dead. You saw for yourself his demeanor cross-examination. You remained calm, even while asked very difficult questions. He held his emotions in. not showing them in public. It's very common for men not to show their emotions. Do not judge you based on his scoping skills. That is not proof beyond a reasonable doubt. But you don't have to guess at what his demeanor was like that day. We know what it was like. He was on Sheriff Heuman's body camera. You watched him yourself. Sheriff Heumann accurately described his demeanor as somber. Somber means sad, serious. He answered questions. He was quiet, but it was clearly he was somber. Both Agent Turbot and Deputy Paler testified that he had a flat affect, or that he spoke with a flat affect, consistent with someone who was being depressed, or perhaps not in the medical definition of shock, but had certainly received a strong psychological shock. Again, people cope with trauma in different ways. Mr. Koehn was home on the weekend. He told you about the fact that Ms. Harris was bringing Sterling out of the room, but that he still had the blankets on him. It shows Dr. Huntington's testimony was that if those blankets were left in the place that they were, and were brought out exactly like Mr. Koehn said that she was, those eggs would not have been disturbed. Those eggs still, but the evidence does not support what the state is arguing for. Mr. Koehn talked with us about the light in the bedroom, and the state is faulting him for not recognizing Sterling in the bedroom and the loss of weight on the other sides. First off, we have to recall that Mr. Koehn is getting home very early in the morning. It's likely dark. We also heard from Mr. Koehn talk about the lamp that was in the closet, about the concerns about the overhead light hurting Sterling's eyes. We know that in that bedroom, as the state has told you, there was a quilt hanging over the window, which would have kept the room dark. The state has talked about this quilt and the heat in the room, and I would remind you that the thermometer readings place it about 5 degrees Fahrenheit warmer in that room than in the rest of the house. I believe the testimony was 76 degrees in the rest of the house and about 81 degrees in that room. We all live in Iowa. We've all been through an Iowa August. August in Iowa is not necessarily the time you want a lot of air coming in through your window because it's warm and it's humid outside. That blanket also kept it dark in there. Another thing that we know that Mr. Koehn said is he thought that it was SIDS, sudden infant death syndrome. Is that unreasonable? Tony Friedrich was thinking SIDS, or she was thinking it was something respiratory. Again, these are statements that Mr. Koehn is making immediately. He makes a statement like this on the 911 call. He makes a statement like this when someone calls him when he's talking with Agent Turbot. He makes the statement to Agent Turbot. But more importantly than making these statements, in the intervening time between when he calls 911 and when he is arrested, he doesn't run away. Ms. Harris wants to run away. He wants to stay here and find out. These are actions that are consistent with somebody who does not understand why their child died, and a grieving father who wants answers. He's distraught, and he's confused. This is not someone who has a disregard for human life, or who had formed at any time malice aforethought regarding Sterling. Sterling, a child that he not only fathered, but that he literally brought into this world with his own hands. This is a child that Mr. Koehn delivered himself. The state has come before you with some sort of flimsy evidence about, well, there were some comments with his brother about how he maybe didn't think that this child was his. And that supposedly leads to some sort of malice against this child. And there is absolutely no evidence of that whatsoever. To remind you, Mr. Koehn was raised in a household where he was not biologically related to his father, he's not biologically related to his mother, he's not biologically related to any of his siblings. And you will also recall that when Mr. Koehn and his brother were talking about this, that Zach's response was, even if he's not my son, I'm the one that knows his father as a father. This is a child that when the child was born after he delivered it, he called Randy Harris to say Sterling was born. He called his brother, he called his father. Sterling passed away. He was the one who notified his family. These are all actions consistent with a father who loved his son, who trusted the son's mother, and who was distraught at the death of his son. Even the fact that Sterling slept in that swing shows that Mr. Koehn was not intending to neglect or hurt him. Sterling was born with respiratory issues. Randy Harris suggested sleeping up. Tony Frederick has heard medical professionals make this recommendation to children with respiratory issues. They were following Randy's suggestion to help Sterling. The state has not shown or proved guilt in this case beyond a reasonable doubt. In fact, they're stretching so far to try and get you there, to argue that turning on a light or laying down in the bedroom is an intentional act leading to murder. Use your common sense. Those are not intentional acts leading to Sterling's death. Now, I want to remind you that as the court has instructed you, Mr. Koehn, there's no burden of proof in this case whatsoever. We don't have to prove anything. I believe the evidence in this case does show what happened. It's natural for us to say, how did this happen? Well, early on, we know that the parents were meeting Sterling's needs. Sleeping, sitting up because of respiratory needs. They were feeding him, providing diaper ointment for a rash, changing wipes, meaning that when the sensitive skin had a problem, they changed the wipes to address that problem. Changing diapers, both changing dirty diapers, changing the type of diapers to address any skin issues. Providing organized diaper bags to a babysitter. Using sensitive stomach formula to prevent diarrhea, to stop the diaper rash. Trading for and spending money on proper supplies. Something happens in the month of August where there's a steep decline in the care of Sterling. What is that? Well, Mr. Koehn testified that he stopped using methamphetamine. He told you why he used methamphetamine. He used it instead of no dose to keep himself awake. During that period of time, he began to sleep more. It was at this time, tragically, that Cheyenne's depression begins to take over. She's young. She was young when she gave birth to Nala. She was young when she gave birth to Sterling. Instead of one child to care for, she has two. She's abusing substances. She's using methamphetamine. She has relationship troubles, both with her mother, with Mr. Koehn. They're moving around a lot. Remember that Sterling was born in a friend's house. They did not yet have the apartment. Dr. Cameron talks about baby blues, financial stress. You can go down an entire list of things that Dr. O'Hara told us are risk factors for depression, postpartum period, what we call postpartum depression. She was described as being disconnected, not having any joy by Jennifer Schreiber. Two people, Jennifer Schreiber and Isabel Snyder, observed this young mother outside without Sterling for 20 to 30 minutes. The type of behavior that someone who's experiencing severe depression is going through. Depression caused her not to care for Sterling. And I want to be clear. I am not trying to villainize Ms. Harris. Depression is a very serious issue. But she was misleading Mr. Koehn about the care that she was providing. As I told you in the 911 call, he said, well, she had fed him that morning, but she'd just gotten up. She told Agent Calloway that she had fed and diapered him recently. She never told Mr. Koehn that she was depressed. She didn't communicate that to him. If she had, he told us that he would have stepped in and provided care. And how do we know that Mr. Koehn actually would have provided care and stepped in? Because in Mr. Koehn's past, when he has proper information, he understands when he cannot care for a child. Remember his son, Katie. But he was aware of the fact that he and his wife could not care for Katie. He asked his family to step in. But he knew that. He had information. In this case, he did not have information. The state has asked Mr. Koehn when he was on the stand about, well, you're not suggesting that with an 8th grade education you can't care for a child. No, that is not what we're suggesting. What we are pointing out is that with limited formal education, with the lack of communication from Ms. Harris, he did not see the warning signs. I think it's important to bring up that there were people involved in this case who could have seen the warning signs. We know that when Sterling was born, his umbilical cord tested positive for methamphetamine. Had that hospital done its job as required by law and reported that to the Department of Human Services, services could have been provided to this family. Mental health services, financial services, child care services could have stepped in. If you want to fault someone for not understanding what was going on, someone who should have known better, it's the hospital. They're not on trial here, but I do point out to you that there were services available. You cannot hold Mr. Koehn to that same level of culpability. We know that Ms. Harris was the primary caregiver. We know that she was not feeding. We know that she was not changing Sterling. We know that she was aware of the smell because she's the one who placed those wax air fresheners underneath his seat. She did anything that she could do to try to hide her depression, especially her depression from Mr. Koehn. She let it hit her lack of care. It's so obvious it goes without saying that nothing about this case is easy. I want to remind you again that your job is to do justice. Natural to have that emotional reaction to seek vengeance, to want to blame somebody, but that's not your job to seek vengeance. Nothing that anyone does in this courtroom will bring Sterling back. And no one in this courtroom regrets that more than Zach Koehn. Now, as the judge told you, the state has the burden of proof. I had the opportunity to get up here and speak with you again. This is my last opportunity to speak with you. I'm asking you to do your jobs in this case. Do justice by returning the verdict as required by law and as demanded by justice. Not guilty, count 1. Not guilty, count 2. Thank you. Approximately 2 p.m., we were reassembled in the state of Iowa versus Zachary Koehn. Approximately 20 minutes ago, the court was advised that the jury had returned the verdict. We reassembled the attorneys. Mr. Foreman, has the jury reached a conclusion? We have, Your Honor. Would you hand the verdict form to the court? Unlike TV, I read the verdict as opposed to the four-person seating. Defendant, please rise. State of Iowa versus Zachary Koehn, verdict form, count 1. We, the jury, find the defendant guilty of murder in the first degree. Count 2. We, the jury, find the defendant guilty of child endangerment causing the death of a child. Defendant may be seated. Mr. Drowser, do you wish to poll the jury? No, Your Honor. Does the state have any reason to do so?
No, Your Honor.
All right. Ladies and gentlemen, your services here are completed. Thank you very much for the time and your attention throughout this matter. I will come back shortly if any of you have any questions for me. I know Mr. Merton and Mr. Phelps are in the courtroom and may want to talk to you as well, just about your deliberations. But again, this has been a difficult week, and I sincere gratitude and thank you for your service. All rise once more. You can go ahead. Be seated. I will set sentencing in 4 to 6 weeks. This is a non-bondable offense. Then it will remain in custody pending sentencing. I'll order a PSI. I believe we can do sentencing in Chickasaw, can we not?
I'm sorry.
We can do sentencing in Chickasaw County, and that's what we will do. I don't think we have to return to Henry County to do the sentencing portion of this.
No, the state agrees with that. And I think also we could not do the PSI and let that be done at the prison as well.
Because it's non-discretionary. Okay? So I might even set it a little sooner if your schedules, if you two want to coordinate, give me a day, it's to be on a Tuesday. Well, we don't have to do it on a Tuesday. We can take it off the court calendar if we have to. Okay? All right? Anything else from the state?
No.
Mr. Graham?
Nothing from the bench, Your Honor.